Hi there, I'm Savannah Mexto with Manor Law Group, welcoming you to another webinar Wednesday with esteemed estate planning and elder law attorney, Bob Manor. All parents will tell you that no child is perfect. However, we all know that some children grow up to be less responsible than other children. But how do you account for an irresponsible adult child in your estate plan? This week's webinar Wednesday with attorney Bob Manor will discuss just that. Now, before I pass the microphone to Bob, I'd like to cover a few housekeeping details. First, note that even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. Also, if you have a general question today during the presentation, please use the question box. We will save time to review questions and comments during the presentation. If for some reason we don't get to your question, we will contact you after the webinar. Also note that today's presentation will be recorded and the replay will be sent tomorrow so that you can share it with family, friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Manor Law Group have to say? We are a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Our managing attorney, Bob Manor, is nationally board certified as an elder law attorney by the National Elder Law Foundation. He is one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. And of course, Manor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome attorney Bob Manor.
Hi, folks. So this is a really interesting topic and something that I really think does need to be addressed. So we kind of had the headline there, the irresponsible child, but sometimes it's the just a tough life. So we're going to talk about the child that we think doesn't make the best decisions and what we can do to kind of help protect them. But then sometimes, and kind of similarly, there is just those situations where it's not an irresponsible child, but it is someone who has a tough situation. Maybe they have, some medical issues. Maybe they have, some marital issues. Maybe they have circumstances beyond their control. Maybe they got involved in a lawsuit and they were sued. Sometimes it's just they've had a hard life and they're not making necessarily bad decisions. But we have to kind of have a conversation about that too, to say, well, look, if they inherit something from you, is that going to, benefit them? Is that going to get to where we want it to be? And is it going to be protected for them? So is there anything we can do both from the standpoint of making sure that a child who's going to inherit something from us is going to be able to receive the benefit of it, and if they do make not so great decisions, is there a way to protect them? Or if they've just had bad circumstances happen to them, is there a way that we can protect them? And the answer is absolutely yes. In fact, we often recommend this for all of our clients. It is actually a standard part of our standard trust planning to provide some protections for the children. Whether they're responsible and whether they're in good marriages and because the bottom line is we don't know what the future brings, okay? So that's a big part of estate planning, is trying to plan for something that hasn't happened yet. So even, a lot of times we're talking to folks about, well, what happens if you get sick? What happens if you experience memory loss or dementia or Alzheimer's or something like that? But the other thing is, of course, what happens after your death? And what do we not know about your death? We don't know when, right? We don't know when you're going to die. We don't know how much money you're going to have at that time. We don't know how your money is going to be titled at that time. What types of money are you going to have? What types of assets are you going to have? We don't know who's going to be living when you die. We don't know who your beneficiaries are. We don't know what the law is going to be. And so the idea here of estate planning, this is the whole point, is to try to have a plan that's flexible enough to deal with the normal changes in life. Now, in 2020, we had this pandemic. No, I don't know. I'm sure some people expected it or planned around it, but the idea is it showed all of us that things can change very dramatically in a very quick fashion. And so we can't fully predict what the world's going to look like in 10 years. And so the idea of estate planning is making sure that we build in the flexibility and to build in the protections in case we need them. And if everything goes right and we don't need those protections, great. If it turns out we did, that your kids are going through something that is going to be challenging for them after you die, that we have the protections built in. So we actually encourage this type of planning and kind of it's standard planning for any of our trust clients where we do a revocable trust to plan for the protection of the children. So that's the big picture. Let's kind of break that down. What do I mean by that? What do I mean by planning for the children, protecting the children, whether your children are 10 or 70, right? If your children are 70, I'm still going to call them children because it's your offspring. So, well, let's take a look at this and make sure that we're all on the same page about what I mean by these legal documents. And so in our office, oops, sorry about that. In our office, we have often, there's three foundations or three basic structures of estate planning that we do, and sort of planning for the future that we do. I have it listed here as A, B, and C. So A is your will-based plan. So what is another word for a will-based plan? That's a probate-based plan. So that we're planning on expecting that things are going to go through probate court upon your death, and sometimes even before that. And so the idea is not a lot of people want that plan. Not a lot of people want the will-based plan once everything is described to them, but we certainly still offer it, and there are certain circumstances where that's appropriate, and that is something we recommend in some cases. But probably the most common plan in our office is the trust-based plan, the probate avoidance-based plan. So what is a trust? Well, a trust is just a contract between you and your family that authorizes them to act when they need to act. So we don't need a judge to authorize it. We don't need an outsider or courts and that whole process to give permissions and authorizations. We pre-arrange that. A lot of people think that's what the will does. A lot of people think that's what a power of attorney does, and reality is it doesn't. So the trust is often that sort of master plan to say, here's what's going to happen in the event that I'm incapacitated. Here's what's going to happen in the event that I'm deceased. And empowering the people that we want to empower to be able to have that legal authority. But most people kind of stop the conversation when they get to this point, whereas when it's basically just probate avoidance and we're not, you die and then everything gets distributed out. The issue with that, so most people kind of just stop. Sorry about that. I'm trying to use some of these things here. So most people stop right here. You die and that's it, and then everything gets distributed out. And that's perfectly fine. There's nothing wrong with that. The idea here though is, why not think about, well, what could happen? Is there anything that we could add to this to make it so that it will be easier for the family? Anything that would make it so that we can provide protections in case we need protections for the family. So that's clearly going to be the case when we have somebody that needs the the irresponsible child kind of a thing. But it's also going to be the case when there's other things that happen with the kids. And so we include in our planning most of the time, not for everybody because some people don't want it, but a lot of the times now, at least moving forward, and is that we recommend that folks will do what we call the lifetime protector trust for the children. So if we've got the irresponsible child, we can make these lifetime protector trusts sort of mandatory. So instead of getting a check, they get a subtrust. So everything stays in your name while you're alive. Then after you pass away, it gets divided, and your children will get their own individual trust. So if you had 3 kids, as represented here on this page, then then your trust after your death would get divided into 3 trusts, 1 for each kid. And we call this the lifetime protector trust or separate share trust, and this can be protected for their lifetimes. They have access, but no one else does. This protects them from divorce, business failure, accident, nursing home, creditors, lawsuits, all that kind of stuff, all the bad things that could happen to them, right? And so for most folks, we want to provide this protection without taking away their control. So before I get too far into these lifetime protector trusts, I just want to go through this 3rd column just to make sure that we're all on the same page. Just to recap, we have the will-based plan, which means probate, the trust-based plan, which is what most people do, and then we have an asset protection plan. So for some folks, they say, well, this is all fine and well. I'm glad that we're setting this up. We're making sure we have permissions in place. We're providing protections for the kids. We're providing protections for ourselves in the event that that we get sick. We have some protections in the event if I go into a nursing home, but I want to go a little further than that. I want to make sure that if I live a long life and live to 100 and I need to hire a home care person to come in and help me in my home, that I might be able to qualify for veterans benefits or Medicaid benefits or nursing home benefits. And that's what the asset protection plan is for. So those are the 3 foundations of planning in our office: will-based plan, trust-based plan, asset protection-based plan. Okay. Today, we're going to be focusing on this lifetime protector trust for the kids. So like I said, we often will set this up for everybody, but today we're going to be focusing on those folks that either we consider an irresponsible child or just a child who's had bad circumstances happen to them. And so it's always sometimes easier to understand this when we use examples. So in my example here, we've got 3 kids: Susie, Roger, and Danny. And Susie, maybe Susie makes good decisions, except that she's in a challenging marriage. And so we say, boy, oh boy, you know, I don't want to take away Susie's right to make decisions for herself. I want her to receive her inheritance, but boy, oh boy, I really wish that her spouse wouldn't get his hands on it. Her spouse wouldn't get part of it if they get divorced. You know, those types of things. And so that's one of the reasons why we use these lifetime protector trusts. And so often what we can do with these lifetime protector trusts is that Susie has primary control. Susie has realistic control over it. You've now passed away. You're deceased. You're leaving 1/3 of it to Susie. Susie has control of it, but it still is protected from divorce. It's protected from creditors. It's protected from things like that. Now let's talk about Roger. A lot of times in my examples, I use Roger as just a business owner whose business failed, and so he has a lot of debt. But today, for my example, we're going to use Roger as that irresponsible child. So let's say Roger has had some drug and alcohol problems, or Roger has had he can't keep $2 in his pocket, and he has, you know, all these issues, and we just frankly don't trust Roger to be in charge of his own money. Well, with Roger's umbrella here, which is what we call the Lifetime Protector Trust, or what we represent the picture of the Lifetime Protector Trust to be the umbrella. For him, we can't put Roger in charge of it. So Susie would be in charge of hers and still have the protections there from divorce and all those types of things. Roger, we can't put Roger in charge of it. So who do we put in charge of Roger's? We could put Susie in charge. We could put your brother in charge. We could put an accountant in charge. We could put a bank in charge. We could put, you know, in other words, we have to have somebody else who can make the decisions for Roger, because Roger can't make decisions for himself, or he's just made bad decisions. And the idea is, by doing that, we can set this up in a way that is not going to be subject. So Roger doesn't have access to the money. He's going to check with whoever we put in charge. They have veto power. So in my example, let's just imagine we decided that Susie's going to be in charge of Roger's trust. That can be challenging because now, Roger might resent Susie. So sometimes it's better to have somebody outside of the family do that. But just for the example here, let's say that we decided to put Susie in charge of Roger's share. Susie has veto power. So if Roger wants to take the money out and buy beer for all his friends or whatever, I don't know. One of the attorneys here, the example she gives is that they spend all their money on fireworks. They do this big fireworks display for their friends or whatever. But the idea is Susie has veto power. Susie has control of that money. But there's a second advantage of having Susie in control of that money is because if Roger has financial troubles, the people that he owes money to can't come and grab that money because Roger doesn't have control over it. Same thing with Susie. If Susie's money is under the umbrella, is in her trust, if she owes money to people, they can't come and take that money out of the trust. There's protections in there from that. But it's particularly important for Roger because, well, what if Roger did have some, financial troubles, but let's say even law enforcement troubles. Let's say he had a drinking problem or something like that, and he has these debts that maybe he owes to, maybe he was in jail and he has to pay back, penalties for that or something like that. Well, this money isn't subject to that. So this money can be used to make sure that we protect Roger, but it's not going to be subject to payback for jail or payback for anything else, or if he runs up a debt, they can't garnish it. Even if he has a credit card, they can't garnish it because Susie has the veto power over it. And so his creditors can't come and take the money. And that's another advantage of having, the third party in charge of it in the circumstance. Like I said, there's protections there for Susie, even though she's in charge of her own trust for all intents and purposes, but it's even a stronger protection for Roger because he's not in charge. So then let's I usually in my example here, I'll give Danny as somebody who has special needs. Maybe he's on disability. And these types of trusts can also be used to protect assets for somebody on disability, make sure they continue to qualify for their medical benefits, their disability benefits, all of that. But let's give another example for Danny. Let's say for Danny that he's just kind of lazy. He's not disabled, he's not special needs, he's just kind of lazy. And let's say you have lots of money. So good for you. You have lots of money and you say, boy, oh boy, I don't know that I want, let's say you have $3 million and 3 kids and each kid is going to get $1 million. And you say, boy, oh boy, I don't know if I want to leave $1 million for Danny because then it's just going to encourage him to be lazy. Is there anything I can do in the trust to provide to incentivize him? And so we've done this a number of times, and people will do this for their grandchildren sometimes, they'll do it for their children sometimes. And one of the provisions that we've created at times was to say, okay, yep, Danny, there's $1 million here, but you can only access it if you also get a job. And the scenario that we've set up is they say, okay, well, if you make $20,000 this year, you'll get $20,000 from the trust. If you make $100,000 this year, you'll get $100,000 from the trust. In other words, we're incentivizing work. We're saying you don't get the money unless you work, and we'll double your money. So if you get a job and you make $40,000, you'll get another $40,000. You'll be able to take $40,000 out of the trust. But if you only make $9,000 this year because you decided not to work, even though you were capable of working, then you only get $9,000 from the trust. And that's a provision that we put in there a number of times for folks. We've particularly done this for grandchildren and things like that, where we say, okay, grandpa and grandma have done really well in life. They've got a good amount of money. We don't want to create lazy children or grandchildren. We don't want to incentivize them not to have a job. Now, everybody has their own opinion on that. I'm not saying whether that's a good or bad. It's an option. And the idea behind this is it's your money, and we should be able to set things out in a way that's going to provide the benefits that you want and to provide the protections that you want. So those are the examples. So in my example here, I have 3 kids. Susie's fine, she's good. We just want to provide protections for her in case bad things happen in the future. Roger makes bad decisions. We want to make sure we control his decisions. And Danny is lazy, and we're just trying to incentivize him to be less lazy. One of the other things that we'll do sometimes with a Roger is we'll say that he doesn't get any distributions unless he passes a drug test, or those types of things. A lot of parents don't want to control their children from the grave. They don't want to put those restrictions on it. So we would leave it where there's not those restrictions like we have with Susie. So she'll be able to take the money out whenever she wants. And that's, I think, a good plan. But sometimes if we have, as defined by the title here, an irresponsible child, sometimes it could be harmful to give somebody who's irresponsible or makes bad decisions. It'd be harmful to give them. So if you give a drug addict lots of money, is that going to be good for them? Maybe, maybe not. Maybe it will just kill them. And I've had that case before too. I've had a grandfather that came in and his son had just recently died. And then the grandfather got diagnosed with a terminal cancer. And he said, well, my estate plan right now says everything's going to go to this, or a good chunk of it's going to go to this granddaughter. She just lost her dad. She's gotten into drugs. If she gets this money free and clear, it'll kill her. She will overdose. She'll buy drugs, she'll go on a bender, and she'll die. And so we got to stop that from happening. And we can definitely do that with trust. It's one of the reasons I like trust better than wills as a planning technique, because we can we can put whatever details that we want into it. We can put whatever ins and outs that we want into it, whatever protections that we want into it, and we can discuss the ins and outs and the consequences of setting things up that way. So that's my thought process on dealing with either children that are irresponsible and don't make good decisions, or children that just had bad circumstances in life, or even the ones that are doing quite well, but we don't know what the future brings, and we want to just provide them with these optional protections. So it's something that we highly recommend. So anybody have any questions for today? And if you don't have any questions typed in now, you can type it into the question box there or the comment box. If you'd rather get just talk to us and have a conversation that way, Savannah is here to give you some information about how to get to talk to us and how to get more information or get your questions answered, or maybe even set up an appointment with us. So Savannah, if you want to go ahead and take over and kind of explain that process.
Sure. Thanks, Bob. And thanks for everyone for joining us today. As Bob mentioned, we do have some easy ways for you to get in touch with our team. Of course, you can always give us a call. Our phone number is 1-800-990-6030. Again, that's 1-800-990-6030. You can give us a call. You can also, if you look in the chat, I've put the phone number and a link in the chat. The link, when you click that, it will take you to a calendar. You can choose a day and time when a member of our team will give you a call. So maybe you can't call us right now and you're not in a position to write down the phone number, or if you're like me, you'll write it down and then lose it 5 minutes later. You can click that link and then just have us give you a call in a day and time that works for you. I will be sending an email in about 15-20 minutes. You should get that. It will have that link in the email as well. So you can click from there to make an appointment, or you can even respond to the email. And I'll be able to help you and get you in touch with the right person. So again, check your inbox, that's coming. You can give us a call, or you can click and schedule. Thanks again for joining us today. We will see you next week.